Hello, everybody, and welcome to the fourth of our DRBF Connection webinar series for Region 2, Common Law, Civil Law Dispute Board Members, Does It Matter? I am Georgiana Tekuc, a member of DRBF Board of Directors Region 2, representing Europe, and I'm your host for today. For those of you new to DRBF, I would like to start by saying that the Dispute Resolution Board Foundation celebrates 25 years this year, being established in 1996 as a non-profit organization by a group of professionals involved in construction dispute resolution. Their goal was to promote the use of the dispute board process and to serve as an educational resource center and information exchange for owners, contractors, and DB members. It also may be of interest to note that DRBF is publishing a dispute board manual, a guide to best practices and procedures. It also published last year a best practice guidelines for virtual DB proceedings that comes with a checklist for DB members in preparation of those virtual DB proceedings. Today's topic was suggested to us by a public authority employer from a civil law country, which has recently started to use dispute boards and is curious to know what could be, if any, the impact on the DB process and its outcome if it does not discriminate between civil law and common law background of dispute board members. And we refer here to the general background of the DB members and not to the legal profession as such. Well, we'll start by saying that dispute boards are a creature of contract, and as such, the basis for the decisions made by the dispute board is grounded in the law of the country in which the contract is performed or the country agreed by the parties, and is that law that ultimately governs its execution. The major law systems which govern contracts, and as I said, ultimately the dispute boards, are the common law and the civil law. And I would like to quote here from Cyril Stern's book on DB practice and procedure. The original difference between the common law and the civil law was the common law developed by custom and practice, beginning before there were written any laws, and continued to be applied by courts after there were written laws. Civil law developed out of the Roman law of Justinian's Corpus Juris Civilis. Codification is not the only difference between civil and common law. More importantly, it is the methodological approach to codes and statutes. In civil law countries, legislation is seen as the primary source of law, and the courts base their judgments on the provisions of codes and statutes from which solutions in particular cases are to be derived. Courts thus have to reason extensively on the basis of general rules and principles of the code, often drawing analogies from statutory provisions to fill any gaps in understanding of the statute and to achieve coherence. In the common law, cases are the primary source of law, while statutes are only seen as an incursion into the common law and thus interpreted narrowly. Another difference between the common law and civil law countries lies in the methods used by the judiciary. And if in the USA, the judges are seen as balancing the power of the other branches of government, in civil law France, the concept of separation of powers is accomplished by assigning different roles to the legislator and to the judges, with the judge being the mouth of the law, à la bouche de la loi. That is why, under the civil law, the concept of binding precedent does not exist to the same extent as under the common law, and under nowadays perhaps exists a little bit more with the influence of the EU legislation for the EU member countries. And certain civil law systems are based on the inquisitorial system, similar to dispute boards, rather than the adversarial system of common law countries. Now, one of the consequences of these differences, for instance, is the existence of some similar yet different legal concepts which may affect the reasoning process of the dispute board and the decision. And before getting further, I would like to introduce to you to our speakers today. And I'll start with Adriana. Adriana is specified as a civil engineer with 35 years professional experience as a designer, construction manager, and consultant with a master in construction law and dispute resolution from King's College in London and a PhD in construction project management. She is a FIDIC expert, dispute board in Europe and Asia, and she has delivered as a FIDIC accredited trainer trainings to more than 1,000 participants in Europe, Asia, and America. Sean Gibbs is a member of the DRBF Region 2 board and the CEO of global expert provider Hanscom Intercontinental. Prior to this, he has held directorships and senior positions with contracting and consulting firms globally. With over 30 years experience across the global onshore and offshore construction and engineering industries, Sean has worked across all the world's continents. He has acted as a quantum expert before various dispute resolution tribunals, including adjudication, dispute board, expert determination, and arbitration. Sean sits as an arbitrator, adjudicator, expert determiner, and dispute board member. And our third speaker, whom you cannot see as yet, and hopefully he would manage to connect. He is now in Kathmandu in Nepal and experiences some issues with the internet connection. But when he will join, hopefully, you would know that he is Emilian Treister, a civil engineer specialized in project and contract management and in claims and disputes management. As an independent consulting engineer, for the last 10 years, he has been involved in many contracts at management level of the FIDIC engineers team. In this capacity, he gained extensive experience in administration of the contract, as we said, mainly under FIDIC conditions of contract, covering all stages from the preparation of tender documentation, tender evaluation to contract administration. He has also conducted many trainings on FIDIC contracts. I would like to now ask our speakers about the jurisdictions they have worked in and whether their common law or civil law background has influenced their DB work. I want them to think about an example, if any, where the differences between the system of the applicable law and their own background or the background of the DB members they've encountered had any impact. And of course, here we refer to the negative possible impacts on the outcome, respectively, on the decision. And I would like to ask Sean to start. Please, Sean.
Can you hear me now? Yeah, that's good. Sorry about that. I'm Sean Gibbs. My home jurisdiction is England and Wales. Quite often people think that the United Kingdom is a homogenous legal system, and it's not. English law is the law of England and Wales. I've worked around the globe, and I'm just going to touch upon the projects and whether they were in a civil code or common law country. I did a university project in the United Arab Emirates. The UAE is a civil code country. Worked on coal-fired power stations in South Africa. That's a common law country. Worked on a hotel and office project in Azerbaijan and Baku. That's a civil code country. A water treatment facility in Arequipa, Peru, which is a civil code country. A steel plant in Odisha in India, which is a common law country. Now, people say that common law and civil law countries are the main split in the legal systems, but the civil codes between civil countries can be extremely different. Even in just South America, the civil codes aren't the same. So I'd say it's important for whoever's going to work in those jurisdictions to be aware that when they come from their own background, there will be some principles that are the same and there will be principles that are not. So it's extremely important when you're working in another country to do some background research. And typically when I'm doing this, it will be a comparative study of my home background and the laws in those countries. For example, in the United Arab Emirates, which is a civil code country, it was a FIDIC 1987 Red Book. The FIDIC 1987 Red Book had been heavily amended, and they introduced a hybrid adjudication process that had been modelled on the UK adjudication system. There were a total of 8 separate adjudicators that determined about 240 different disputes. And what was important was that any party that referred a dispute made legal submissions as to the governing law and how it impacted on the contract terms and their application. So this might be running arguments that they could overcome a time bar because of good faith arguments and just enrichment and other matters. What I say is that in any country, that expert evidence is required not just for delay, quantum and technical matters, but also on the governing law and how it should be applied to the matters in dispute. If a party doesn't do this, it runs the risk that the tribunal may incorrectly apply their interpretation of the local civil code or in a common law country, statute, or even case law. So I would stress that it's so important for parties to be able to recognise that if their case is fundamentally pinned on the law, they must deduce evidence to that fact. Legal submissions don't necessarily need to be made by lawyers. So, for example, in the UAE, there are a number of recognised translations of the civil code that people will use, and they're actually in English. The particular project in the United Arab Emirates, the language of the contract was English, all documentation was in English, and all of the dispute resolvers were native English speakers, and there wasn't an issue on that. Where you do sometimes have issues is if the civil code has numerous translations, and these translations aren't accurate translations, and then it quite often will require expert evidence to be given, and it's likely to be given by a lawyer to explain how those particular civil codes should be interpreted. Now, what I'd stress at this point is that it doesn't matter where the dispute board member's from. What is important is that they recognise that wherever they are, it's not going to be the same as their home jurisdiction, and they should be open and alert to this, and they must deal with it. And it's very much one for them to make themselves aware of what the fundamental differences are, be alert to it, but also be open to receiving the submissions from the parties when they point out these differences, and try not to apply something that that is established in their home jurisdiction. I'd now like to hand over to Adriana.
Thanks, John. I agree fully with you. Although my experience is in civil code countries, presently I'm on 7 dispute boards in Serbia, Bulgaria, Uzbekistan, and Ukraine. And all of these countries have civil codes. And I fully agree with you that it is very important how the parties present their cases. And of course, the dispute board to be open-minded and to understand the differences. So the education of the adjudicator is very important, really. And working for more than 10 years with FIDI contracts, I understood that some of the concepts are not clear for me. That's why when I was 50, I started my study at London to learn about common law. And now I understand all those differences. And when I use relevant FIDI case law, I know how it should be treated, how to be applied, and this is very useful. So the background knowledge is very important. And as you say, otherwise, if you understand the differences, you just have to receive the presentations of the parties. And if you need expert evidence, then it could be also helpful. In my experience from recent dispute resolution from this year in an Eastern European country, the contractor's referral contained reference to some articles from the civil code of the country and from the commercial code, and it said article 100 and this, etc. Article this and this, etc. So I asked for clarifications, and I also wrote to the parties that they have to submit everything is in English, because this is the language for the dispute board. This is the governing language for the contract. So when I received the submission, of course, it was containing the relevant articles, and one of them was extremely important for this dispute resolution, and I really used it in my reasoning, and I saw that this can work properly. But of course, it is very important how the parties prepare, and they should include only relevant materials, and they should not flood the dispute board with laws and regulations which are not relevant, because this is expensive. It is interesting for the dispute adjudicator to read those things, but then the cost for dispute resolution will go higher. So it is very important the parties to give the relevant information, to give it in English, and as Sean said, the translation is also important. In my case, the translator was actually the Chamber of Commerce, so the translation was really of good quality. Okay, thanks. Now to Georgiana.
So, Adriana, you think that if you once you cleared the situation and they gave you only strictly the relevant information on the law, you think that if you would have had a common law background, if you would have been a dispute board member from UK, let's say, you would have understood their legal argument once they gave you the relevant, or so it didn't matter to you whether they were civil law or common law. Okay.
Of course,
So
of course.
From what Sean and you have said insofar, I think we could get towards a conclusion that practically it's not so much the background of a dispute board member or another, as it is more about the qualities and the experience and the knowledge of the dispute board members. So I would like to ask Sean to tell us a little bit about the qualities that may be and skills that may be required from the UK adjudicators. And then I'll ask Adriana to do a comparison, if you want to mirror it, in talking about the DAB members as in FIDIC, whether ad hoc or standing DABs. Sean, please.
Thanks, Georgiana. As I'm sure most people are aware, we've got a statutory adjudication process in the United Kingdom. And I'm going to talk about the requirements to join two panels. One's the UK Adjudicators, which I was the founder of, and also the Institute of Civil Engineers. Now, UK Adjudicators, nominating body, requires people to submit a CV and an application form. Now, this is to make sure that they have a professional qualification relating to their primary profession and a minimum of 10 years post-qualification experience in their primary profession. Now, the profession could be anything. It could be architect, engineer, it doesn't matter, but it should be construction related or construction lawyer. Now, if people are already on one of the recognised adjudicator nominating bodies, there's no further demonstration necessarily of training and experience in adjudication. If they don't hold these, it might be that they use the RICS diploma in construction adjudication to demonstrate their capability, or qualifications by any of the other professional institutes, whether it's the Chartered Institute of Arbitrators, TEXA panel, or TECBAR, which are both lawyers. Or it could be that they demonstrate that they're able to do this, having undertaken an academic course in construction law, such as offered by King's or Robert Gordon or Leeds Beckett. As part of this process, they demonstrate their knowledge, skills, and experience. That's both in terms of construction, but also in law. They need to demonstrate an understanding of the law relating to construction contracts and how this would be applied to matters such as evidence and other things that would arrive. Also, what they also have to demonstrate is that they've got some active involvement in the adjudication process, either as adjudicator or party representative, and an objective assessment's made. So it's clear that anybody on the UK Adjudicator's domestic panel would have been through a thorough process. Now, the ICE, the Institute of Civil Engineers, has a similar requirement. There are entry requirements that you must either be a fellow of the Institute of Civil Engineers or the Chartered Institute of Civil Engineering Surveyors. They do have possible exemptions for lawyers, and they similarly have requirements about obtaining legal qualifications, whether it's the ICE's own training or not. They also require people to have been in a management position for 10 years, or if it's a solicitor or barrister applying, to have 20 years post-qualification experience with construction law. They also have a prescriptive list of the contracts that people might have experience in, whether it's the NEC, the IChemE, FIDIC, or ICC, etc. Now, what is clear is that people who are adjudicators from the United Kingdom and have their experience in the United Kingdom have been through a training and vetting, but also experience. Now, that experience means that they're able to apply themselves to problems. And it doesn't matter if they're in their home country, because of their training, they're aware that laws are different. And they also understand how laws and contracts interact. So, for example, in some countries, you can contract on whatever basis as long as it's not illegal. And the laws won't necessarily impact upon the contract. In other countries, some parts of the civil codes, for example, in the United Arab Emirates, can't be overwritten, such as prescription on the period for claims. And because people have had all of this training and experience and have the skill set to apply themselves to the matters, there shouldn't be an issue with them operating either in their home jurisdiction or another jurisdiction. I suppose one of the dangers is that people become complacent or lazy, and then when they do work in another jurisdiction, they might not do the necessary background and research, which means that they might not be aware. Or sometimes they might have done thorough research, but they might have issues. For example, in Peru, it's hard to get good quality translations and explanations in English of all of the civil codes and their application. So it's so important, once again, to emphasize that the parties need to make appropriate submissions. And if the dispute board does have concerns, they can take their own evidence. So, for example, they might instruct an expert or local lawyer to assist them. But, and I would stress this, it doesn't matter if you come from a common law or civil law background, it's your openness and willingness to engage with the parties and understand the information that's presented to you, and then make a logical examination and reasoning of that information and reach a decision, and communicating that decision effectively so that the parties can understand it. And in dealing with the decision writing, that it's written in such a way so that people can understand how you've arrived at it. And it might be that it's because of the evidence, it could be because of the particular interpretation of the contract, or it might just hinge on the way that the law's been applied to the particular contract. But it's the skill sets of the individual and the qualities of the individual that would appear to me to be more important. In all honesty, I've been very lucky in all of the matters I've been involved in around the world, that where you've had 3-member dispute boards, they tend to have been a mix of backgrounds in terms of the legal jurisdiction, and also that those dispute board members were diligent and thorough in the work that they did. They acted fairly and impartially, and they were able to understand the submissions put to them and then deal with those submissions and make their conclusion. I'd like to now to invite Adriana to take over.
Thanks, Sean. Absolutely agree with you, because I'm lucky this year to be on 5 dispute boards where we have common law members, and I really appreciate the interaction, and I don't think that there's a difference from the background because I see how reacts a member who is from a civil code country on the same problems, and how reacts one who is from country from common law background, and really the education, the attitude, it makes the difference, not where you come from. This is the lesson I have learned also, but it is really a very good a situation when there is a diversity, different points of view, and you can discuss with someone, because when you are so adjudicator, it's much more difficult and not so interesting. But anyway, you have to manage in all cases. And I would just like to go back to FIDIC contracts in this case, because here in the warranties of the adjudicator, we have the requirements which are very straightforward, to be an experienced, knowledgeable in the type of work which the contractor is to carry out, and experience in the interpretation of construction and engineering contract documentation. So this means that the adjudicator should be experienced working with the relevant contracts, and should have the background of understanding of the construction works as well. So FIDIC is not saying that you must hire someone who is on a list, but people are always wondering, are we obliged to take someone from the FIDIC president's list or from another list? No, there is no such restriction, but it is highly recommended to have someone who has been through some exams and whose knowledge is proven, because in some cases I hear about adjudicators who are, for example, professors in law, who think that they know all legal concepts, but they haven't worked with FIDIC contracts, and they cannot properly manage the tasks of the dispute board because they have not such experience and training. So every adjudicator should approve at least the relevant training in the relevant procedures, because this is not something that should be turned into arbitration, because this is very dangerous. Sometimes people who have no experience in dispute boards may go to turn the process in arbitration, and this is not the goal, because here we are talking about different process. And I think that really the books that I have read during my study in London, like Coulson's book about adjudication, I could recommend to everyone, though it is for statutory adjudication, but the requirements, the things about conflict of interest, about ethics of the adjudicator, about impartiality, all in this thick book is relevant for every adjudicator. So there's no difference. Okay, Georgiana.
Georgiana, could I just make a comment? I didn't mention it, but obviously with the new FIDIC 2017 forms of contract, the DAB is now being replaced by the DAAB and dispute avoidance. And I think we should also touch upon the necessary skills to help the parties avoid disputes. And I think the dispute board members on their visits and their interaction and when they read correspondence, even if they're not on the site, can quite often spot issues, and they can make a suggestion to the parties of ways that they can overcome these. And the only way that they're able to spot potential issues before they arise and try to diffuse them is by having the practical experience and knowledge. And also understanding all of the different documents and reading them thoroughly. So quite often you can read a progress report. Somebody might read it and not spot anything, whereas somebody who's experienced and trained and qualified and worked on projects can spot issues that are flagged up there. So for example, it might mean that they spot that all the float's being used up in a program. That means that anything that happens in the future is going to cause a critical delay. Such things as that don't tend to be in the realm of academics and those who theoretically practice. It's really in the practitioners. That's not to say that you have to be a construction professional. as I've touched on before, you get lawyers that specialize in construction law. And because of their interaction with construction disputes, projects, and the documentation and the issues, they're alive to these matters as well. Thank you.
Yeah, I could also add something, Georgiana.
Yes, please.
Yeah, because continuing the thoughts of Sean, I know how important it is to think also about the differences in the technical standards and also in the building control, because a lot of risks are there for the commencement of the works, for the design approval, for permit for operation, for defects liability. So really, when you are standing board, you are in a much better position. And during the site visits, I myself always ask for clarifications. For example, is the design approved by the expertise in some Eastern European countries? It is still a state building control authority, which sometimes delays the process, or I'm asking some clarifications about the commissioning tests and the approval procedures related to connection to utilities, to permitting, because each country has different laws and provisions. In some countries, for example, utility operators are private entities and have different regimes. And in many cases, in my experience, there will be delays of the project related to such agreements with authorities or utility companies. So again, if you are from UK or from Eastern Europe or from another part of the world, every country is different. Even every region might have different regional regulations. So always the key is in that to be impartial, to be qualified to understand the differences and to ask about them to be presented by the parties.
Thank you, Adriana. So what I heard so far from both of you, from Sean and Adriana, irrespective that we talk about UK statutory adjudication, or we talk about FIDIC dispute boards, or we talk about dispute boards in general, what I heard three elements: training, vetting, experience. So when we talk about training, I would say not only that, as Sean put it, actually, construction professionals, irrespective if they're having a technical background or a legal background, I think that an engineer, an architect should have the minimum knowledge, the concepts knowledge of legal aspects. So he could interpret, because the contract lives in a, it doesn't just suspend in the NANT, it's living in a jurisdiction, in an applicable law system. So they should be able to understand the how the technical aspects are dressed up in the legal concepts on one hand. On the other hand, the construction lawyers should have enough technical background or enough technical knowledge to understand the technical issues which cause problems in the contract, and that will go to those professors who, without any experience, would assume because they know the law they could actually interpret what's going on into a dispute board and how the matters should be addressed. So training-wise, it doesn't matter where they come from, but both sides of construction professionals, technical and legal, should have the minimum knowledge of the other sides. On the second topic, it was the vetting of experience. And I heard Sean saying 10 years post-qualification experience for UK adjudicators, or 20 years for construction lawyers, or from ICE, or 10 years for post-qualification experience for technical professions. And so that means that for someone to trust you and to entrust you with his or her matters in a contract, they definitely need to know that you're capable to understand and to handle these matters. And theory would never been enough, because practice is never theory, right? It is theory mixed up at all levels with all the possible implications and obstacles that you never thought about being possible in the real life. So that's where the experience comes in. It also builds up on the level of trust of a certain professional who could be brilliant, as Adriana said, at a theoretical level, but could actually fail in terms of experience. And that takes us to the practical experience being the third point. How could, excuse me, how could someone who has been through the training, whether legal or technical or both, has been working on a site or has been involved in contract management, in construction contract management, how could they get to the point where they become dispute board members if everybody wants, at a certain point, someone experienced to deal with their issues? How do they gain that experience in terms of dispute boards? How do they become a dispute board member? Sean, from your experience, what do you know? How does someone get to the point when says, I want to be a dispute board member? How do I become one?
Really, they need to get involved in not just the construction delivery, but they need to get involved in the claims and disputes that arise. I see a lot of people that have worked in the dispute and claims side sector for many years before they'd even dare to venture to consider that they might have the necessary experience to become a dispute board member. We're very lucky at the moment, and I say we're very lucky that FIDIC have now set up a FIDIC credentialing service for adjudicators, but that at the moment is essentially the end, i.e. you take the testing and you become accredited. And I know Adriana will be able to explain this in more detail. So it's the step getting to that point. So I know we've touched upon King's College that provide a construction law course. So they'll teach somebody how to write an enforceable adjudication decision or arbitration decision. And essentially, apart from the dispute avoidance and helping dispute avoidance, which really is down to soft skills, the hard skills are someone has to be able to take on board a lot of information, process it, analyze it, and write an enforceable decision. And that really requires some form of training and final assessment. So people could either do a course at King's. The Chartered Institute of Arbitrators offer both arbitration and adjudication training. The culmination is that you write an enforceable decision. So there's various routes to get to that point, but it's really sorry, you're going to pose a question, I believe, Georgiana.
Yeah, I was thinking, yes, that's the training part. So that's what you need once you have the post-qualification experience, once you had the original training. Now you get the training as how to write a decision, how to do that. But how do you translate that in practice? Because I remember that the year I graduated from the law university, I knew all the theory, but I was not able to apply it to practice. At that time, at least, the connection between theory and practice did not exist. So you know the theory. How do you apply it to practice? And I would like to ask Adriana, because I know she is a member of a mentorship committee of DRBF. And how does she see the translation into practice of that theory?
Yes, I think that this is a very important topic because I know for myself how many years it was difficult for me to start being an adjudicator, although I thought I had the necessary theoretical knowledge and I had a lot of construction management, claims management experience, but I couldn't get listed, and it was very complicated to gain the real experience. At that time, the requirements for the FIDIC president's list were to have been adjudicator, not only to be helping on the side of the engineer as I was, or being involved with one of the parties practice in the whole process. It was not enough. So this was a very difficult moment for me. And that's why when I joined DRBF all the time, every year I'm trying to organize some mock process, first of all, because the process is confidential and only the lucky ones can be part of the hearing or part of the whole process. And I think, first of all, what DRBF does as events with mock site visits, for example, we have done mock hearings. The whole process, when it is made like a funny scenario, it is very useful for everyone. But of course, this is just the theater. This is not the real thing. That's why I was very enthusiastic when the idea came up to make a mentoring and pupillage scheme within DRBF. So after long discussions and work on it, it came out that it would be difficult to develop the pupillage scheme, because in this scheme, the adjudicator without practical experience will be shadowed by someone experienced, but the parties would not like to have someone inexperienced. So that's why actually it was voted the mentoring scheme to be developed. And Georgiana, I'm really very happy that with your support, with some fresh blood in the group, now it's going to happen, and it's really becoming a very useful document, the guidance which is under development, almost ready. And this mentoring scheme will be extremely useful for those who have already the knowledge, but they can shadow the dispute board members, and they can help with the management of information, with the management of the agenda, to manage some of the virtual files and information which is flooding nowadays. So I think this will be a great opportunity. And of course, we have also some qualification criteria, but mostly the group has been influenced by the criteria which Sean mentioned, and those for FIDIC adjudicators, so it is nothing which is higher or unusual for the people who get onto the scheme. And this would be published, I think, soon. Georgiana, what do you think?
I hope so. We're definitely getting there. So thank you, Adriana. I would like to go through the chat, though. I've asked people kindly, please put your questions into the Q&A. Scrolling through the chat, BIPLAB is asking, does it mean that construction law degree is a must apart from engineering degree? Sean, what do you think on that?
I've got to be honest, and I quite often put forward people to act as dispute board members, and I'm looking for a well-rounded person who has both practical in terms of the vocational construction that can demonstrate that, but also some sort of legal knowledge. The disputes that go before dispute boards tend to be high value, and parties won't have confidence in people if they don't see that they have the full skill set. And parties aren't going to take the risk. They can quite often be arguing over millions and millions of dollars in these disputes, and they don't want to entrust that to someone that they don't have total confidence in.
Okay. Adriana, I think there's someone asking, how long did your course at King's lasted?
Okay, so when I was enrolled, it was possible to be certified in 1 year. But when I had to start, this was over. So now you do the master's. I was doing it part-time. So we had a long weekend in London every month. This is 6 times going to London, and then you go for the exam. And this was for 2 years, including the dissertation which you develop. So you can work, go on with other things, of course, no social life, almost all the time you have to study in between.
Exactly. You want to be a good dispute board member.
Yeah, but you can do it also full-time for 1 year.
Oh, okay. Okay, good to know.
Can I just jump in there?
Please. Yes, yes.
I think it's important to stress that you never stop learning and developing if you're going to be a dispute board member or a practitioner.
Absolutely.
In claims. And if you think you're going to do something in 2 years and that's it, you're never going to have to study again.
Absolutely.
You're doing yourself a disservice in terms of your future development, but also you'll be doing other people a disservice.
Exactly.
Because you have to keep abreast, refresh. For example, whenever I work in a new country, I'll study the laws, do a comparative study,
Exactly.
take qualifications. So, for example, I've just done the NEC Project Managers Accreditation course this year for the NEC 4. People would say, well, why are you doing that? So I need to be able to, one, know that I do know what I'm talking about and I can demonstrate it. So don't think that you can just do a bit of training. If you're really committed to this, it's going to be a lifetime of learning and development.
And I would definitely recommend it to civil law lawyers, because civil law does not recognize, at least for now, remember that environmental law did not exist back in the 90s, or the IT law even later than that. So I would definitely recommend to civil law lawyers who do not have the concept of construction law as such to take as much training as possible in common law, construction law, because not only that you get a grasp on the common law concepts and the differences and the similarities on the legal concepts, but you also get a grasp on the technical knowledge, those notions that you need to understand a technical contract and what happens during construction management, or what happens during a project management, and why and what and how to deal with it. And now, Sean, a question for you from Dushan. What are the main differences between common law and civil law which you recorded when you're dealing with dispute resolution? Sean, you mentioned notice requirements. Can you shortlist others? That's an extensive exercise.
To be honest, in the few minutes I've got available, it's not possible to do that. But just let me give a couple of examples. I'm going to take the example of the United Arab Emirates. So there's various civil codes. When you look at the civil codes as a whole, it's not clear always if a contract clause will be applied, because there are conflicting provisions in the civil code. Some would support its application, strict application as it's written, and some would temper the harshness of it. And I don't want people to listen to this and try to use it as a legal argument. So I'm not going to be specific in this. It's just more to alert them that this does happen, and that it's important to be alert to it.
Yeah, correct. Now, from Melith Mendes, there is a question, and Sean and Adriana. Should the understanding of the differences between civil and common law be an important part of becoming a good DB member? Yesterday, Sean and I were in the FIDIC Adjudicator assessment. Congratulations and fingers crossed to both of you. And only one case scenario out of 3 said that the project country identified a project country as a civil law jurisdiction. Should we emphasize more on understanding by a prospective DB member of the good faith protection in civil law, of how delayed damages are treated differently in the two systems, what is performance of the contract in the two systems, etc.? Well, Melith, I would say that is exactly what we said so far. Any dispute board member needs a minimum knowledge of legal concepts, and they might be different from a country to the other. They could overlap, but they're never identical. Even in the same legal system, whether common law or civil law, they're never identical. So yes, they need a minimum knowledge. And in terms of whether they should know to a great extent, no. Adriana was telling us in her example in Ukraine, I think, that once she got the extensive description of a civil code, she said, stop, I don't need all this. I need you to identify exactly the relevant provisions that I need to interpret this thing. On the other hand, Sean has said as well that under the common law, it is good that you have some guidance, from precedents and the rest, but you still need to keep up to date and read and learn about evolution of things. And whether you work in another country or not, you need to get to know about the system in the country you are appointed a dispute board member. Gonçalo Vieira in Portugal, and he says, if the civil law of certain country does not predict dispute boards, I'm not sure I understand what he means by predict dispute boards, how can DB decisions be mandatory? It's difficult to implement consistent with national law right now, at least in Portugal, not the idea of DB, that's more or less consensual, more and more. Okay, so I would say, Gonçalo, that as we said, dispute boards are a matter of contract, a creature of contract, and in particular in civil law jurisdictions, as long as the law does not forbid it, is allowing it, therefore the DB decision, once decided by the parties, could become mandatory, binding. As about prediction, I'm not sure. Sean, what do you think he refers to by predicting DBs?
I think that a lot of the civil code countries haven't updated their civil codes sometimes for 50, 100 years more. And at the time, there was no such thing as a dispute board. You know, there was no such thing really as alternative dispute resolution, other than for the last, hundreds of years, we've had negotiation and arbitration. So the civil codes haven't necessarily set out anything to do with the dispute board. So then it turns on contract law.
Exactly.
And if the local courts or the arbitral tribunal are willing to enforce.
Okay, so to go to David Glenading question. Well, in terms of civil law, I would suggest, if you already have a background in common law, I would suggest that you look for the theory of obligations and torts. For us are together, so what you call contract law and tort law, and principles of law. So that will be your basics.
Can I just jump in there?
Yes, please.
Obviously, I've mentioned the King's course. I believe Sorbonne University do an English language civil construction course, and I believe that either Stuttgart or Frankfurt do a similar course. What you might find is, if you're an English speaker, you might struggle to find a civil law course that's in English. But I was going to say they are right there, but you need to look around, and if you don't know one, or you need a recommendation, get in touch with somebody, say such as the DRBF. Numerous members of the DRBF actually teach on the courses at different universities. They can tell you
exactly. But also keep in mind that nowadays the main law university in every civil law country would always have foreign language trainings. So Bucharest, for instance, has a specialized in French. There are others that do English as well. So you will find in various languages civil law training courses. And as Son said, let us know. Now, we only have a couple of minutes to conclude, and I would like to go through our conclusions, though. We were asking Sean very quickly, 2 minutes, and then Adriana, please. I would like your final words to refer to, is it necessary for the adjudicator to know the specific governing law? It is necessary for the adjudication to know the specific technical standards and procedures for the site opening and commissioning in the country of the site. And what is more important, the academic knowledge, the practical training, intelligence, or former experience? Quickly, please.
Okay, so I'm going to answer point one. Is it necessary for the adjudicator to know the specific governing law? No, but they must be aware that the governing law may impact how terms of the contract and other matters are construed. Parties must make submissions if the law is required to be known to determine the matter. That's the second point now. Is it necessary for the adjudicator to know the specific technical standards and procedures for site opening and commission in the country of the site? And once again, it's not necessary to know the specific technical standards and procedures, but you must be aware that these could impact the decision-making process. Once again, parties must make submissions if these are relevant to determine the matter and bring it to the tribunal's attention. Now, thirdly, what is more important, academic knowledge, practical training, intelligence, or former experience? Well, I certainly wouldn't want somebody with just one of those skill sets to be my dispute board member. I think that you must look at them as a whole, and that makes a well-rounded individual that can properly apply themselves fairly and impartially, determine the dispute in accordance with the submissions made, the evidence, the contract, and the law.
Adriana, please.
Okay, I fully agree with everything. And for the standing dispute boards, I would add that it is very important to have a mixture of soft and hard skills so that they can be proactive during the site visits, and also to hear, not only to listen, to hear, and to help the parties. So they would act like the relative who is always ready to help, but not like the evil mother-in-law interfering with the work of the parties.
Great, thank you, Adriana. Before we go, I would like to invite you all on 8th of July to our DRBF Insight Series webinars about DABs in FIDIC Gold Book, containing some Ireland case studies, for instance, and some others as well. And on 15th of July to our educational webinar about dispute boards in MDB's financed contracts. And before that, I hope to see as many of you as possible in Lisbon on 30th of June and 1st and 2nd of July to DRBF Annual International Conference, especially that, as I said before, this year, DRBF celebrates 25 years. You have in the chat the link for the registration to the conference. You find our webinars and more on the calendar on the DRBF website with this. Thank you very much, Adriana. Thank you very much, Sean. We regret very much that our colleague Emilian couldn't join us. Apparently, a major issue has been taking place also on his site in Nepal, not only internet issues. And thank you, everybody, for joining us today. See you soon.